This is actually a video response to Professor MTH, and it's regarding Justice Scalia and originalism. First, I actually would recommend that my viewers check out Originalism, a quarter-of-century debate. It was forwarded by Justice Scalia. It's a book that's really, really good, and it explains the debate between originalism and basically judicial activism. And the basic question for me, for everybody, would be that let's just take a topic, let's take an issue, like let's take prostitution, and say in the 1900s prostitution was something that people frowned upon, and that's why we subsequently banned it. And then come 2000, 2011 even, the public perception of prostitution changes. And it says, well, it's not so bad. You know, the Equal Protections Clause now means that prostitutes should deserve equal protection under the law as any other ordinary citizen for some reason. All right? How many people would trust the Supreme Court on their judicial decisions at that point? Why vote on anything? If the Supreme Court can change your vote, why would we even need a legislative system? Why not let all the courts around the United States just decide what laws are valid and which ones aren't, and, you know, however they skew it is okay? And that's the point about originalism. Why would you want a system that was more activist than it was originalist in origin? It just doesn't make sense to me why people tend to have a view of a activist position as far as judicial review and the Supreme Court's opinions. It's like, for example, Roe versus Wade was really never, in my opinion, it was really never intended to go that way. And it's not because whether or not, as Justice Scalia says, whether or not abortion ought to be allowed or not ought to be allowed. It's a question of whether or not the states are specifically prohibited from making those things legal or illegal. And apparently, you know, we've been doing it for the longest time. And I'm not saying just because we've been doing certain things for a long time is a criteria for whether or not we should allow something or not. That's exactly the opposite of what I'm trying to propose. Originalism is basically the original interpretation of the Constitution. Okay? What should be allowed and what shouldn't be allowed under the constitutional law. The point is, if you want the Constitution to be interpreted a certain way, then you should vote on a certain amendment to be legislated. You should vote. You should move to vote to get the Senate active, or the House of Representatives active in making something happen, and then signed into by executive orders or whatever it may be. My point is, the legislative process is there so that the people have a participation and a voice on what they want to be legal and what they don't want to be legal. And certain questions of legality in the constitutional sense are pretty plain and simple. There are some, you'll find out if you read Originalism, Quarter Century of Debate, you'll find out that their originalism isn't perfect, but it's pretty darn good. Because it's like, for example, equal rights never came about because of certain amendments necessarily. It came about because we had the Civil Rights Act of 1964 that afforded women equality, that afforded blacks equality. You know, Jim Crow laws, gone. I mean, they were already gone by that point, but also, I mean, the separate but equal funding for schools. We're going to have the black schools and the white schools, and even though we're going to have segregated schools, we're going to have equal amount of funding. How dumb is that? I mean, there are counties where they had maybe 5 Japanese people, and they separated them into, like, one school and they had to have equal funding for that school. I mean, it was totally ridiculous. The Civil Rights Act and the legislation that had and the effects that had is my point. It wasn't some piece of the Constitution that changed it. It was because we legislated these laws that made it so that equality is something that we all share. We voted on it. The citizens wanted it. And that's my point. Constitutional interpretation swaying one way or another shouldn't be the determining factor of whether or not we should have equal rights or equal protection clauses or whatever people think. No, it's because we're able to vote on certain things that we want in our society and what we don't want. And whether or not the Constitution specifically prohibits those things from being enacted upon, for example, like freedom of speech, it is prohibited for the government to step upon with certain limitations. And so that is specifically prohibited by the Constitution. But the equality, whether or not we have slaves in America, is not specifically prohibited in the Constitution. It even mentions it. And it wasn't until the 14th Amendment or in the 15th Amendment that we actually prohibited slaves from being in our United States of America. So my point is this. My point is that originalism, to me, I think is the better interpretation than an activist position. Because the activist position basically says, oh, well, whatever I think that society demands at that time, we should be able to afford, legally speaking, to the question of a constitutional legality. And I'm sorry, I disagree.